All right, the next case this morning is State of Florida. This is Susan Vincent. Hopefully this argument won't be quite as dramatic as the last one was. Would you like to reserve some time?
Yes, I'd like to reserve 5 minutes for rebuttal, please.
All right.
May it please the Court, my name is Rebecca McWigan, and I represent the State of Florida in this matter. The State is appealing the downward departure sentences on Susan Vincent on 3 cases. The trial court gave 3 bases for the downward departure. The first, that it was an isolated, unsophisticated incident for which the defendant had shown remorse. The second was her need for specialized treatment. And the third was the need for restitution outweighs the need for incarceration. The standard of review is mixed here. It's, questions of law are reviewed under de novo, and questions of fact are reviewed under abuse of discretion. As to the first ground, you have to show 3 elements in order to downwardly depart on that basis. First, that it was committed in an unsophisticated manner. Second, that it's an isolated incident. And third, that the defendant has shown remorse. The State disagrees that the first and second elements of that downward departure basis have been met here. The first is the unsophisticated manner. That, as I said before, she was being sentenced in 3 cases here. There was no evidence presented as to the first 2 cases, how they were committed, and as to the third, it was committed in the same fashion as the first 2 cases by prying open a door and gaining entry into the home for the burglary. She entered the house with the specific intent of finding Mrs. Onotava's hydrocodone pills and taking them home with her, which she accomplished, and she hid them in a plant when she was there from the police, and they weren't recovered until she sobered up from her drug-induced haze and confessed to the police as to where those were. The fact that she was high on drugs at the time she committed the offenses isn't enough to make them unsophisticated. This court found in State v. Thompson in 2003 that alcohol use was not enough to make actions unsophisticated, and the legislature specifically found that substance abuse or addiction is not a basis for downward departure. It also wasn't an isolated incident. She was being sentenced for 3 separate burglaries committed on 3 separate dates. The first one was June 2nd, the second was June 3rd. On October 27th, she was arrested for possession of cocaine and paraphernalia. On November 15th, she was arrested for DUI. She was convicted on both of those arrests at the time of her sentencing, so she had a prior felony and 2 misdemeanor convictions at the time she was arrested, and she was apparently on probation at the time she committed the 3rd offense and referred to drug court, and she was stealing specifically for the intent of the drugs at the time of the 3rd crime. As those 2 aren't shown, this isn't a sufficient basis for downward departure. The second ground for downward departure was her need for specialized treatment. This court and other courts have found that you have to show that the Department of Corrections is unable to provide the treatment. It's not available, and there was no showing of that here. Defense counsel conceded in his closing that the Department of Corrections could provide this treatment, and so therefore that is also not supported as a downward departure basis. And finally, the need for...
In the Spiak case from the 5th, that requirement was not imposed. Is that correct?
That's correct. In the Spiak case, that requirement was not imposed. However, there's been 4 cases, at least out of this court since then, that I cited in my brief, that have imposed that requirement. One of them cited as a but-see to Spiak, but still followed Thompson, which was a 2000 case, and aligning this court with all the rest of the districts that show that in order to downwardly depart under that basis, that you must show that the Department of Corrections cannot provide that treatment. It's not available.
Why shouldn't we remand this case to have further evidentiary hearing on whether or not there is specialized treatment available, given the multiplicity of conditions that she suffers from? Well,
she had a first sentencing hearing set, when was it? On December 27th, 2004. They specifically continued that hearing because they said her evaluations were not completed and the doctor refused to come in and testify as to her problems and the specialized treatment that she would need until they were done. The hearing was continued all the way until September 27, 2005, at which time they provided no medical testimony and no testimony from anyone from the Department of Corrections. So she's already had 2 opportunities here to provide that information to the court, and she didn't do so. And the third basis was the need for restitution. Only one of the 3 victims was awarded restitution in this case. She specifically asked the court to give her the maximum sentence possible. She didn't ask for restitution. Her main complaint, besides the fact that her house was ransacked while Mrs. Vincent was looking for the drugs, was that her jewelry that was one of a kind and not replaceable was taken, because you have to show that the victim's need for restitution outweighs the need for incarceration. That's also not supported by this basis. And also the other 2 cases had no restitution, so again, those would need to be remanded under this basis. Since none of the 3 have been supported by substantial competent evidence, the sentences in this case are an abuse of judicial discretion, and we ask that this court reverse and remand for the imposition of at least the minimum recommended sanction. I'll reserve the rest of my time for rebuttal. Thank you.
Thank you, counsel.
Good morning, judges, counsel. May it please the court, I'm Nancy Ryan, representing the appellee, Susan Vincent. The trial courts retain some discretion in sentencing, and as Mrs. McGuigan correctly concedes, the burden of review in this case is not purely abuse of discretion. It's a bipartite standard of review. The question, according to the Supreme Court's decision in, I believe it's Banks, states that on the question whether the judge should have departed, the standard of review is abuse of discretion. On the question whether the judge could have departed, it's whether the judge followed the correct rule of law and whether competent substantial evidence supports the judge's findings. And here you've got both. Clearly the correct rule of law was followed. The arguments made in the trial court and the basis for the ruling are precisely the same as the arguments made here today. Clearly, I submit also you've got competent substantial evidence to support at least 2 of the judge's reasons for departure. On the health issue, as Judge Lawson pointed out in State v. Spiak, the holding was that the elderly lady involved in the case had so many health problems that it was patent from the record that she couldn't get the same care in DOC that she could get on the outside. Interestingly, the more recent cases the state relies on for a principle that a defendant has to bring in a doctor from DOC or somebody who's very familiar with DOC's medical procedures. Interestingly, those cases are distinguishable from this case in Spiak. In Abrams, relied on by the state, Mr. Abrams only had an HIV-positive status. He didn't have full-blown AIDS. He just had an HIV-positive status. And the second DCA in that case noted, well, we haven't seen any evidence that that couldn't be dealt with in prison, just the same as on the outside. In Sherber, the case relied on by the state in supplemental authority, the defendant had ADHD and bipolar syndrome. In Green, the other case from the second DCA relied on by the state, the defendant had hepatitis C and post-traumatic stress disorder. In all 3 cases, as I noted, the second DCA said, well, we haven't seen any evidence this couldn't be dealt with by DOC. Those are conditions or statuses for which the defendant could be handed a pill or 2 pills in a little cup in the morning. Here we've got a case more similar to Spiak. Here we've got suspected congestive heart failure. We've got suspected lung cancer. They couldn't reach a diagnosis on this even with a 3-month gap in the hearings because she had a major infection in her lungs that couldn't be cleared up by that time. In Spiak, the defendant had cancer, coronary heart disease, diabetes, as well as a host of other life-threatening illnesses. I submit this case is right in line with Spiak, and what the holding there was that given the nature and extent of the illnesses, successful treatment in prison was doubtful. I submit that that's the case in this case as well. And there's another reason for departure that's supported by competent substantial evidence. That's whether there was remorse, lack of sophistication, and isolated events. The state concedes that there was remorse shown in this case. The state conceded that in the trial court and concedes it again in the briefs. As to lack of sophistication, I submit that the circumstances under which Mrs. Vincent was arrested speak for themselves. She was dragging a red Flyer wagon down the street with the items she stole in it. She stole a pencil sharpener.
Isn't the state correct that that's only with respect, even if you take that as a lack of sophistication, there's no evidence as to how the other crimes that were being sentenced were committed?
That's true, Judge, but given this extremely amateurish modus operandi, I think it's reasonable to infer that there was a lack of sophistication here. There was no evidence that she attempted to sell or pawn any of the items taken in any of the burglaries.
But on the third burglary, didn't she break in specifically to steal the hydrocodone that she knew the victim had?
Yes, she did admit that.
Doesn't that evidence some level of sophistication?
I'd submit that it's not, because that's the burglary where the toys were also stolen, the pencil sharpener was stolen, she was caught in broad daylight. I submit that that burglary does, that the circumstances surrounding that burglary do support the judge's finding. I submit that you've got some items of substantial competent evidence to support that
How can
finding.
you distinguish that from the case in De Leon where the defendant was riding a bicycle and selling cocaine to an undercover officer? If that is not unsophisticated, how does this one become unsophisticated? How do you distinguish the two?
Well, I submit that riding a bicycle to sell cocaine is not in fact unusual and not in fact unsophisticated. It's just a mode of transportation. Maybe he didn't have a car. But here you've got a woman walking down the street in broad daylight. She got caught. She got seen by one of the neighbors dragging stuff out of one of the neighbors' house down to her own.
Well, didn't she also break in through a back entryway where she wouldn't have been observed?
She broke into the sliding glass doors in all the cases. I submit we've also got isolated offenses based on this court's precedent in State v. Merritt. The court held in Merritt that both the terms sophistication and isolation should be construed most favorably to the defendant based on the rule of lenity. That applies to the guideline statutes as well as to substantive criminal statutes. In Merritt, there was a series of offenses which was held to be isolated in the context of the defendant's career. Here we've also got a series of offenses that took place only in a space of 6 months. The DUI and the possession of drugs took place between the burglaries. And before this spate of crimes, you've got a model citizen, you've got a social worker and an Army specialist. She became entangled with hydrocodone after, in the course of her social worker duties. Her neck was broken for her. And that's another reason to support the medical reason for departure. She needs physical therapy on her neck.
How can we say that 4 separate incidents, we've got the 3 burglaries and then the October arrest, how can we say that those are isolated events?
Based on State v. Merritt, where there was a series of events, but they were compact in time and based on the defendant's entire career, I'd rely on Merritt. And I'd also point out that only one of the reasons for departure needs to be valid for this court to affirm. And I submit that based on State v. Spiak, I think unquestionably we've got a reason for departure that's supported by the record. And we'd ask the court to affirm.
Thank you very much.